In today's video, I want to talk with you about what it actually costs in terms of an overall investment to register a trademark. We're talking filing fees, we're talking legal fees, we're talking everything in between. Ready? Let's do this. Hi, welcome back to the channel. My name is Jim Hart. I am a trademark lawyer. We help entrepreneurs of all types get their brands protected through federally registered trademarks. And today, I want to talk with you about what it actually costs to register a trademark. If you're an entrepreneur who's looking to build and grow a brand, then this is something that you definitely want to take a look at. And it's something that you really need to be informed about in terms of the overall investment it's going to take to register a trademark. Now, it's important to understand that when it comes to trademarks, you have a trademark. If you're selling under a brand, if you're selling products, if you're selling services, whatever it might be, you already have trademarks. What we're going to be talking about today is taking those trademarks you already have, and maybe you have some common law rights to them. I've talked in other videos about why common law rights are not actually that strong in terms of trademark protection. But today what we're going to be talking about is actually taking those trademarks you already have and registering them with the US Patent and Trademark Office and what it actually costs to do that. Now, a lot of entrepreneurs never take this very crucial and important step for their business because, frankly, they're confused by the legal process and they're scared about what it's actually going to cost to get them to register that trademark. And so that's why I really want to demystify this for you here today. And I also want to share with you that there's quite a bit at stake if you ignore this, if you ignore protecting your brand. And what are some of the things that could happen if you don't pay attention to registering your trademarks? Well, you could waste a lot of time and money investing into a brand that you don't actually own. That's probably the biggest problem that I see most people face, most entrepreneurs face when they're talking about registering trademarks. If you do not register your trademark, then you could become an accidental infringer. Somebody could steal your brand. Or worst case scenario, at some point later on down the road, you could be forced to actually rebrand and come up with a new name and maybe even be forced out of business because you don't actually own the name to your brand because you never took registering your trademarks seriously and gave it the time and attention that it truly needs and deserves for your business. So today, let's talk about the different factors that go into play when we're talking about what it actually costs in terms of a monetary investment to register your trademarks. And before we do that, I'm feeling a little parched, so I think I need to have a sip of coffee from today. We're going with the UK mug. I realize it's been a couple weeks since the coronation. I don't really care that much about that, but I do like the mug. So cheers. British mug, Portuguese coffee. Good combo, I think. And as if on cue, there's the dogs. All right, so I've got one dog staring at me between the legs, and I got another dog sitting over there licking his crotch. So we're ready to record a video. The first thing you need to be considering when determining overall cost and investment of filing your trademark application is when you're actually going to be filing the trademark application. Then we're going to be talking about your approach to filing the application. What process are you going to be using to get your application filed? Then we're going to be talking about the number of classes and applications that you actually need to file to totally protect your brand. And then finally, we're going to be talking about who is actually going to be doing the filing of the application, because that's certainly going to play a role in this overall cost of registering your trademark applications. All right, so first things first, let's talk about when you're going to be filing your application. And why is this important? Because historically, the Trademark Office has been raising rates during the past several years. At the end of 2021, they raised rates, and now we were just notified last week, I believe, that they've got a number of new rates on the table that may take effect sometime in the near future. If I had to guess, I would think early next year, maybe like January 1st, but we'll see. They have not been approved yet, but these are the new rates they're thinking about. Right now, it costs $350 per class for the standard application, which is what most lawyers use because it gives us a lot of flexibility and we can do more with an application at the standard application than we can with the plus application. A lot of do-it-yourselfers use the plus application, and there's nothing wrong with that. It just, in certain cases, it doesn't fit into what it is that we're trying to do in terms of your overall brand protection. But the Plus application comes with a $250 per class filing fee. So you can see there is already a distinction there, $250 versus $350. What the Trademark Office is actually talking about doing right now, and they've written a post about this, I'll include a link down in the description below. What they're talking about doing is eliminating the Plus application entirely and making everything under the standard application, but charging more fees if you decide that you want to do a custom description, which is what a lot of lawyers will do. We want to make sure our clients are protected, and oftentimes using the standard descriptions that the Trademark Office gives us just doesn't give our clients the level of protection they need. So if you want to do a custom description, it's an additional $100 on top of that. So that's number one. Number two, you have to be aware that if you are filing your trademark application as an intent to use application, then it's going to be slightly more expensive because you're going to have to pay to file a statement of use or an allegation of use later on, versus if you are filing an application with actual use in commerce. So if you're on the fence about whether you should file an intent to use application or you should file an actual use application, and really the question here is whether you're going to file your application when you're actually using your trademark in commerce or not, then my recommendation would be you really want to get that application filed as early as possible, because the filing date is what's going to be used in terms of giving you priority for that trademark. So if somebody else wants to go in and file a trademark before you, even though you started using the trademark earlier but you did not file a trademark application, then they're going to have priority over your application. So that's an important consideration that you really need to be thinking about. All right, so the next consideration that will go into how much it's actually going to cost you to register a trademark is the process you use for registering that trademark. What do I mean by that? Well, what a lot of entrepreneurs do and what they think is that they can DIY their trademarks and they can just log into the USPTO database and they can put in some information into the application form, submit the application, and in a couple months after the Trademark Office gets to examining their application, they're going to get a registration. And while that does happen for a very small percentage of entrepreneurs or business owners who are looking to do this on their own, the likelihood of that happening is actually quite small. And that's because there's just so many places where people can mess up trademark applications. There's so many places where the examining attorney is going to look at your application, find a problem, and issue what's called an office action. Those happen in about 50 to 60% of cases, even from files that have lawyers assigned to them. We just don't know what the examining attorney is going to find when they look at your application and what they might really grab onto to say, you know what, this is an issue that we need to dig deeper into. So there's a lot of places where people can mess up, and that's just filing the application. The other main concern here is that a lot of people file these applications blindly. They don't ever do a search. And one of the things that lawyers can help with is we do a comprehensive search ahead of time and let you know if there's anyone else out there that's using a name that is the same or similar to yours that's going to cause a problem with the Trademark Office. And that's important to do. And a lot of people just file these applications without doing the search. They use the wrong ownership on the application. They use the wrong class of goods or services on the application. They aren't sure what to use in terms of goods or services. They think, okay, well, I'm selling t-shirts, so that's going to be class 25, so I'm going to file for that, forgetting the fact that they also probably need to register a web store, or maybe they have an online blog that's producing content that they also need to register for, which are in different classes. So there's a lot of things that go into filing a trademark application that a lot of people don't necessarily understand. And if somebody says, well, yeah, I filed my trademark application on my own and I got my registration, if you're talking to another entrepreneur at some sort of conference or meetup or something like that, and they tell you this and they tell you that you don't need a lawyer to do it, I would say, well, let's look at that registration. Let's see what they actually filed for. Let's see what they actually got. And let's see what types of classes of goods and services they were approved to sell in, because not all trademarks are created the same. And this is going to be a big determining factor in terms of your overall cost. And why do I say that? Because If you don't invest the time to make sure your application is filled out correctly from the very beginning, if you don't do a comprehensive search, if you don't have the wrong details and information on your application, if you mess any of that stuff up, then in all likelihood, you're going to have to pay a lawyer to redo that application for you later on. Or alternatively, you may run into a situation where you never actually get that trademark that you are trying to register. And then we go back to the same problems that we said at the very beginning of the video. You become an accidental infringer, somebody steals your name, you're forced to rebrand, any of those things. So that's the second thing I would say is, what is your process for how are you deciding, what trademarks you're going to apply for, what you're going to be putting on that application, what class of goods and services you're going to be selling under, because that's all really important and it's going to impact your overall investment or cost in registering your trademarks. Which brings us to the third factor that's really going to impact the overall cost of your trademark, and that is how many applications you're going to be filing for what intellectual property assets, and how many classes of goods or services are you going to be listing on those applications. And here is how this can easily kind of get out of control if you don't know what you're doing. Each application has a separate filing fee. So people that think, okay, well, I'll just file my name and logo, that's good. But no, that's actually two separate trademark applications, one for your name, one for your logo. If you have a slogan, that could be 3 applications. If you have a line of products or services that you want to trademark and they each have a different name, that can be additional applications on top of that. So depending on where you're at with your business, I've got clients that hire me to do 4 or 5 trademark applications at a time. That's not unusual, and it's usually because they have a line of products or services and they want to make sure all the names of all those products are properly protected. And there are people out there that file thousands of trademark applications. There are companies, I should say, that file thousands of trademark applications. But for you, as an entrepreneur, when you're just getting started, we really want to focus on your brand name. We want to focus on a logo if you have a logo for your brand, and we want to focus on a slogan if you have a slogan. Now, these things usually can be used in terms of your podcast name, if that's something that you want to make sure is protected, YouTube channel name, different things like that. You can make sure all of those things are protected with one of those 3, the brand, the brand, the logo, and the slogan. Logan, maybe I should trademark that name. That's pretty good. You can't actually trademark unless you're using it in commerce. I kind of like that. Anyway, one of those 3 is probably going to work for you. Now, the other thing I will say about this is with each of those applications, again, you have to determine what category of goods or services are you going to include on that application. And this is where a lawyer can really help, because a lot of people, as I mentioned before, get confused. They think, okay, well, I'm selling t-shirts, I just include t-shirts. But if you're selling t-shirts, if you're selling, if you've got an e-commerce store, if you have a blog, if you have a YouTube channel, all of those things could fall under a different category. Now, there are 45 categories of goods and services that encompass any product that you can purchase in the United States, or any service that you can purchase in the United States. So picking the right category is going to be really important. And this is something where if you mess this up, if you want to add on additional categories to your application, you actually have to file a brand new trademark application. Again, there's going to be cost and time and money and all those things that go into that. So you can see how these things can easily and quite quickly increase the overall investment it takes to get a registered trademark, especially when you have multiple applications and multiple classes. So just for an example, make sure you're getting what I'm saying here, and you probably are. If you do, skip ahead 20 seconds. If you have 1 application, 1 class, that's a $350 filing fee. If you have 2 applications in 1 class, now you've got a $700 filing fee. If you've got 2 applications in 2 classes, now you've got a $1,400 filing fee. So you can see how these things can stack on top of one another and actually increase quite quickly if you are not filing in the appropriate classes. And as I mentioned, way back in factor number 1, towards the end of this year or even next year, it's very, very likely that the costs and the filing fees for all of these things are actually going to continue to go up. So the last factor is who is doing the work. And I realize this sounds overly simplistic, but you need to understand there's really three options you have for how to file your trademark application. You can DIY it, which it's free on the one hand. On the other hand, if you mess it up, then you're going to have to pay a lawyer to either refile your application for you or to try and fix the mistakes that you made on your application in the form of responding to an office action, which actually can be much more expensive than if you just hired a lawyer to file your application for you in the first place. So that's the first thing you need to be aware of, is you can DIY your application. And while it is first glance the least expensive option, it is also probably the most expensive option, because when you make mistakes and you decide to abandon your application, then you're not going to have that trademark you wanted anyway. So it's probably more beneficial to use one of the other options. The second option is a filing service. I'm not going to name any names here, but you know what I'm talking about. It's typically a service that you're going to go to. They're not a law firm. They're not lawyers. They're taking your information and they're putting that information onto the trademark application for you with very little to no guidance at all on their part. So you're basically DIYing it, but paying somebody else to fill out the application for you. So not a great option for a lot of people, because you've still got all the cons of doing it yourself, but you don't even have the benefit of doing it for free. You're paying somebody else to basically file the application for you. So that's the second option. The third option is hiring a lawyer. Now, lawyers can cost, it runs the gamut in fees. I will tell you, I've seen lawyers that charge as little as $150 to $200 for a trademark application versus lawyers that charge, $5,000, $10,000 for trademark applications. And I would say, I'm not going to tell you what an appropriate fee is here, but I will tell you some things that you should look out for. Number one, a lot of lawyers offer flat fees. My law firm, we offer flat fees to do trademarks. That's totally fine. And that happens with a lot of lawyers, especially with trademark applications. But you need to watch out for what is included in that fee. So if you see a fee that's really, really low, maybe it's advertised through Google AdWords or something like that, and they're telling you, $400 trademark application, and you're like, wow, that sounds amazing. What are you really getting with that? How much personal attention are you getting? How much contact with the lawyer to ask questions are you getting? Are they just merely taking your information and putting it in an application the way a filing service would, but they're actually a lawyer that's doing that? Or are they providing you more information and substantive advice? Are office actions included in that fee? Are multiple office actions included in the fee? A lot of times lawyers will include non-substantive office actions, which are very short, quick to respond office actions, but they do not include substantive office actions in their fees. So you want to make sure that that is clarified. Does the fee include a comprehensive search? Sometimes it does, sometimes it doesn't. So you want to make sure that is included in the fee. So there's a lot of different variables here. So if somebody says, well, this lawyer is charging, $400 for a trademark application, this lawyer is charging $5,000 for a trademark application, it's important to understand what are the distinctions between what those two lawyers are offering you. Also, another red flag is, does one lawyer put a cap on the number of classes of goods and services that they will include on the application versus what another lawyer will do? Because every time you add a class of goods or services, as we talked about before, not only does it increase the fee in terms of the filing fees you have to pay, but for the lawyer involved, it also increases the time and effort they have to put into preparing your application and making sure it's done correctly. So those are all different factors that you want to really think about when you're deciding on which lawyer you should hire to assist in this process. If you're interested in learning more about some of the mistakes people make when filing their own trademark application, here's a video I did right there. Thank you so much for watching, folks. I look forward to seeing you in the next video. Have a great weekend and take care. Bye-bye.